I was dealing with a number of DWI cases this morning. The number one way that I win DWI cases is on the issue of probable cause for the arrest. Now, a law enforcement officer has to have a reasonable suspicion in order to pull you over, and then has to develop sufficient probable cause in order to place you under arrest. Law enforcement officer can pull you over for any number of reasons. You could have a light out on the back of your car, on your tag. Your tag could be out. You could be speeding, weaving, any number of things. That's usually pretty easy for the law enforcement officer to get over that small burden that's required, small burden of proof on reasonable suspicion. But when it comes to probable cause in order to place someone under arrest for DWI, that gets a little harder. That requires a number of tests typically. It can be things like slurred speech, strong odor of alcohol, unsteady on feet, poor performance on field sobriety tests. In North Carolina, we have 3 standardized field sobriety tests. Those are the walk and turn, the one-legged stand, and the horizontal gaze and nystagmus. That's where you follow an officer's finger or a pin light, something like that. So what we do when I go to court is work, of course, with my client and their memory about the situation. And then I attack all of those tests. Many times I can get a test or tests suppressed. And every time we get something suppressed, it makes it more and more difficult for the state to sustain their burden beyond a reasonable doubt that my client may have been, or again, probable cause, probably was impaired. And when we're able to suppress those tests, when we're able to find video, most of the officers now have body cam video or car video. We have witnesses. We have recollections of the officers that don't comport with their notes or the video. My client testifies well. And again, I've talked in past videos about how critically important it is that I share all the information, the officers' notes, the video with my clients to have them review those and help prepare for trial, because your testimony can be key to winning your case. And again, I attack these cases, I fight them very hard, and we have what I consider to be an outstanding track record in defending these cases. I find myself very rarely, well, I never, almost never want to do any kind of plea. Sometimes it does make sense. But most of the time, as I say, the best offense is, well, the best defense is a good offense. That is the way I like to play. Like to play rough, like to play hard, like to play for keeps, because it's my client's freedom and their record that's on the line. God bless.